Good morning. This is Kathy Lynch. Welcome to the CRRC Human Resources webinar. Thank you for joining us. We have three very expert speakers today on some hot topics. I'd like to first turn it over to Kelly to give you some administrative instructions.
Good morning. I just have a few pieces of housekeeping for you. I'd like you to please remain muted. This is not going to be interactive other than the chat function of Zoom. If you have questions during the presentation, you can use the chat function to send me your questions privately. I see some folks that are unmuted right now, so I'm muting you. So if you could please mute yourselves and be sure that you are not sharing your webcam with me, that would be great. So use the Zoom function, the chat function, to send me your questions. We will take the questions at the end of each presentation, which is about 30 minutes per presentation. We've got 3 presenters, and we're recording this today. So tomorrow at some point, we will be sending a link with the recording and all of the presentations for you in PDF format. And I think that's it. Kathy?
Thank you. Our first speaker is Erica Frank, who is the Executive Vice President of Legal Affairs for the California Chamber of Commerce. Ms. Frank has over 10 years of legal, governmental, and legislative experience. She is Cal Chamber's subject matter expert on California and federal employment law, labor law, and human resource compliance. She provides expert training for HR professionals, and we are very fortunate to have her here with us today to discuss the Family and Medical Leave Act and the California Family Rights Act. Welcome, Erica.
Thank you. Thank you. Good morning, everybody. Thank you for the nice introduction. So what I'm going to be talking about today is, in addition to FMLA CFRA, the California New Parent Leave Act. That is a new law that just took effect this year in California. It's really targeting small employers. So one of the things as a threshold starting point is these two laws have certain employee thresholds in order for them to apply to your company. So we're going to start with the smaller one, and that's the California New Parent Leave Act. And what that has to do is it applies to employers with 20 or more employees. So if you have 20 or more employees, you need to listen up. What this does is it provides basically what we call baby bonding leave. So it's new parent leave. It's time that an employee can bond with a new baby or a parent that might be in foster care, recently placed or adopted. So when we're talking about how much time, it's actually 12 weeks of unpaid time. So there's no what we call wage replacement here. It's simply time that an employee has to be away from work and spending time with their new child without worrying about losing their job. So as I mentioned a minute ago, it's only to bond with a new child, and there's a time limit. It's within 1 year of the child's birth, adoption, or foster care placement. So that 1 year time is important. The employees who are taking their new parental leave time must receive a couple of things, one of which is a continuation of health benefits. So if you are providing health insurance to your employees, whether it's fully paid or there's a cost sharing, you need to make sure that that employee continues to receive those benefits, even if that employee is not paying their share of the premium. So what you want to make sure is before that employee takes their new parent leave time, you have a discussion with them about how they're going to continue paying that premium while they're out on leave. In addition, and very important to note, that the New Parent Leave Act provides a protection and guarantee of reinstatement to the employee, and that's critical here. So in other words, if somebody goes to bond with their child or takes a leave, they get to come back to their job. They're not going to lose their job. There's liability if they do so. There are new regulations that are pending with the Department of Fair Employment and Housing. That's the agency that is charged with enforcing this law, as well as the California Family Rights Act, which we'll be talking about shortly. There are a lot of unanswered questions with this new law that the DFEH will be addressing in the regulations. And at the end of the presentation, there is a link to the website that you could go to. Right now they have proposed regulations, but they haven't submitted it yet for official comment period. But it gives you a little bit of a sense of what they're trying to do. The Cliff Note version is they are trying to mirror the New Parent Leave Act regulations with that under the CFRA. So they're trying to make them common. So let's talk about what employees are eligible for the New Parent Leave Act. There's a couple of things that they need to meet in order for them to take that time. For one, they need to have worked for you for more than 12 months. Okay, so we're looking at a year period for them to be eligible. So an employee that walks into your office today who's brand new is not going to be eligible for the New Parent Leave. They need to have that 12 months of service. There's also a hours worked requirement of 1,250 hours during that previous 12-month period. So you've got the 12-month period, and then you have the time, the hours worked, 1,250 hours. And then that employee also has to work at a work site where there's at least 20 employees within a 75-mile radius. Now, the thing here that we need to remember is we have the FMLA CFRA that also provides what we call baby bonding leave. And so in an effort to make sure that an employee isn't quote unquote double dipping and taking time under FMLA and then time under the New Parent Leave Act, the legislature said that an employee who is otherwise eligible for FMLA CFRA baby bonding cannot take the parental leave. The only thing that we have to remember, and we'll talk a little bit about this when we get to the CFRA section, is under FMLA CFRA, an employee is eligible if they meet the 12-month requirement, the 1,250-hour requirement, but work at a work site where there are 50 or more employees within a 75-mile radius. So if an employee is working at a work site with less than 50 or more employees within a 75-mile radius, they are not eligible for FMLA CFRA. However, all of you employers out there need to be aware that if that employee who loses eligibility for FMLA CFRA because they are working at a work site that has less than 50 or more employees, but they work at a work site with 20 or more employees, then they're entitled to the New Parental Leave Act. I know, clear as mud. I wish I could make it a little bit simpler, but I did not write this legislation. So again, just keep in mind that 20 threshold if you do have 50 or more. So how much time? We touched briefly about this, but they're entitled to 12 weeks of parental leave. Sometimes we have two parents who are working for us, and the question becomes, well, do both parents receive that 12 weeks of time? And what the law says is that the employees get to share that 12 weeks of time. That's all it says. So employees are going to have to figure out, the two parents are going to have to decide, maybe one parent gets all 12 weeks, maybe one parent gets 6, the other gets the other 6. It's really going to be something that has to be discussed. Now, with time off, there's always going to be a question over how am I going to replace the wages that I'm not earning? Because remember, the new parent leave is just time away from work with job protection. So under the statute, an employee can use accrued vacation pay, paid sick time, or other accrued paid time off, or other paid or unpaid time off negotiated with the employer. So again, if the employee has accrued time and you offer a vacation, and we know that under California's mandatory sick leave law, we're all offering sick leave, the employee can take some of that time. Now, the interesting thing with sick leave is baby bonding is not one of the listed uses under the California sick leave law. However, here we have a statute that's now saying it. So again, you might want to talk to legal counsel about what you want to do. Of course, though, allowing an employee to use sick, even though it's not a listed purpose, I don't know whether that would get you into trouble or not, because it's benefiting the employee, which is always a good thing in the eyes of the law. But talk to legal counsel about that. And then finally, paid family leave benefits. So oftentimes people will say, I'm taking paid family leave. And we always say, well, no, you're not. Paid family leave is a wage replacement. So here, if the employee is on new parental leave time, they're entitled to paid family leave benefits. Now, the paid family leave benefits is for 6 weeks. It's not for 12 weeks. So it's going to be a partial wage replacement administered by the EDD, and the employee is entitled to receive a percentage of their earnings based on a scale and predetermined percentage amount. So like I've been mentioning, the new Parental Leave Act, the real teeth to it is that right to reinstatement. Now, something to keep in mind, in the statute it expressly states that the employer does need to provide a guarantee of reinstatement to the same or comparable position before that leave begins. So when you know that an employee is going to be taking time to bond with their new baby or their new child that's been adopted, it's extremely important that you guarantee their right to reinstatement at that time before they take that leave. If you don't, the statute determines and for you that you have denied the leave. So again, you don't want to be in that default of denying leave when simply you just forgot to let them know that they have a right to come back to work when the leave is expired. As I mentioned before, health insurance benefits, we've talked a little bit about this, but again, do make sure that those benefits are continued. And if there is a shared responsibility for the cost of the premiums, that's negotiated with the employee before the employee goes on leave. Under the statute, you can recover premiums if the following two conditions occur: that the employee has failed to return from leave, and the reason the employee failed to return is something other than a complication or something related to circumstances beyond the employee's control. Sometimes we'll have situations where, for example, one parent decides to stay home with the child. If that parent decides to stay home with the child and doesn't want to come back to work, and there are premiums that haven't been paid, the employer may try to get those premiums, but that's where it gets tricky, and that's why it's a really good idea to make sure, you know, that there's an agreement in place or some kind of contract, if you will, worked out with the employee about recovering those premiums, because it can get expensive. But what you all need to be aware is, even if the employee's not paying those premiums, you still have to maintain them. So that is something that we need to keep in mind. So what are some of the what we call employer requirements and employee protections? So we can't deny the leave, so we need to allow it. We can't refuse to hire, discharge, fire, suspend, expel, discriminate because the employee wanted to use the leave, or because the employee provides testimony or information about the employee's own leave or another person's leave, or provides testimony or information in an inquiry or proceeding related to the parental leave. So the last two bullets are really if the labor commissioner comes in, or the DFEH, or somebody comes in because there's an allegation that the employer wasn't providing parental leave, that we're not going to retaliate against another employee who's basically serving as a witness or offering testimony. So is there a liability for the employer? Why, yes, there is. Where can we get ourselves in a little bit of trouble here? If we fail to provide that 12 weeks of time, if we fail to provide a guarantee of reinstatement, if we fail to return that employee to their same or comparable position, if we fail to maintain benefits, or if we take what we call an adverse action. So that would be disciplining them, just demoting them, discharging them because they've taken that parental leave time. The statute does set up what's called a mediation program. It's a pilot program. However, it's subject to funding, which has not taken place yet. The pilot program is set to end in 2020. Again, that is contingent upon funding. It's through the DFEH. And essentially what it says is, if the employer is subject to a lawsuit for failing to provide the leave, that the employer can request mediation within 60 days of receiving a right to sue notice. The employee can't sue you in court until that mediation commences. However, once the mediation begins, if any party, whether it's the employer or employee, says, I'm done, I'm out of here, then the mediation is over and the employee can pursue a lawsuit in court. All right, so that concludes the new Parental Leave Act. Again, that's something that just took place. All of you who are within that, you might have read between 20 and 49 employees. The reason for that is, again, if you're 50 or more, you're going to be under FMLA CFRA, and unless you've got that small situation where the employee works at a work site with less than 50 but more than 20, the new Parental Leave Act is not going to apply to you. So for those of us that are smaller, that haven't had to worry about baby bonding time, we need to now. Okay, moving along then to the Federal Family and Medical Leave Act and the California equivalent. These two laws pretty much mirror each other in almost, I'd say, about 90%. Where they don't, I will try to flag it for you. Naturally, the California Family Rights Act is much broader than the federal counterpart, but they both have the same or similar eligibility requirements. So let's just talk about that. So what's a covered employer? And as you can see, this tracks just like the new Parental Leave Act, and that was done intentionally to try to avoid some confusion. But essentially under FMLA CFRA, it applies to employers with 50 or more employees and all public employers. Now here's the thing, the employees, those 50 employees, need to be on the payroll for each day of the work week for 20 or more weeks in the current or preceding year. So you've got to look at your current year and look backwards to see where you are. The coverage continues even when you fall below 50 employees. So to lose coverage, there must be 20 work weeks below the 50 employee count in the current and preceding year. Employers who are covered under FMLA and CFRA must also post FMLA and CFRA posters in the workplace and provide family leave policy to their eligible employees. There are some special rules for joint employers. I just have it here. If you use temporary employees, let's say through a temp agency, just note that there are certain requirements or rules. They would be included in your 50 employee count. So who's an eligible employee under FMLA and CFRA? So again, like the new Parent Leave Act, the employee needs to meet all three requirements of 12 months of service in the previous 7 years, and these don't have to be consecutive years. 1,250 hours worked in the past year, and work at a work site with 50 or more employees within a 75-mile radius. Under FMLA, this is separate from CRRC. CRRC doesn't have the equivalent. An eligible employee can be an employee who's entitled to 26 weeks of military caregiver leave, so a little bit different. So what are the qualifying events? The employee has to have a qualifying event in order to trigger that 12 weeks of time. It can be the employee's own serious illness or injury. It can be a parent, child, or spouse's serious health condition for which that employee needs to care for. And then we have that baby bonding, which is similar to the new Parental Leave Act that we talked about. A little bit of a difference between FMLA and CFRA on qualifying events. Under CFRA only, you can use the leave to care for a registered domestic partner with a serious health condition, and baby bonding if the employee has no remaining FMLA time. FMLA only is care for a service member, so that would be a spouse, son, daughter, parent, or next of kin injured while on active duty, and that's up to 26 weeks of time. Exigency leave related to a spouse, son, daughter, or parent who is on covered active duty, or pregnancy. So we don't talk at all today about pregnancy disability leave. That's a whole nother animal in of itself. The takeaway that you should have here, though, is pregnancy disability leave will not run concurrently with the California Family Rights Act, but it will run concurrently with FMLA, and I don't need to confuse you anymore on that. So what would be a serious health condition? A serious health condition is defined as an illness, injury, impairment, or physical or mental condition that involves one of the following: hospital inpatient care, 3 days of absence plus treatment, although under CFRA there is no minimum absence requirement. Treatment resulting in a regimen of continued treatment, chronic, permanent, or long-term conditions, or multiple treatments. What we do know is conditions such as the cold, the flu, that is not considered a serious health condition. So it's just something for you to be aware of as well, particularly when we are in that cold and flu season right now. So baby bonding leave, this should sound familiar to you because the baby bonding leave under CFRA and FMLA is very similar to the new parent leave. It's time to bond with a newborn, adopted child, or child placed in foster care. Again, it is available to both parents. So if you have both parents working for you, they need to split the time. Used within 1 year of birth of the child, date of adoption, or foster care replacement. For CFRA, like I mentioned before, that baby bonding time can only begin after the employee is no longer disabled by pregnancy. If the employee is eligible for baby bonding under FMLA CFRA, like I mentioned before, then they cannot take that new parent leave time, no double dipping. So with FMLA CFRA, for most situations, it's a 12 weeks time and a 12-month period, with the exception of military caregiver leave. You're going to define that year, whether it's calendar year, whether it's moving forward, rolling back. Under FMLA CFRA, there can also be what's called intermittent leave. So they're not taking that 12 weeks of time in one big chunk. Sometimes it might be a week here. Sometimes it might be a day here, a day there. It's going to depend upon what the medical provider provides in their designation. So under FMLA CFRA, there are some notices and designation notices that you're going to need to give to the employee. The key takeaway here is if an employee comes to talk to you and says they need some time away from work for a medical condition, that's going to trigger your obligation to give them the notices so they can take it to their doctor, and then you can help you determine whether it's a qualifying event. Wage replacement for FMLA CFRA, when it's a serious health condition, there's SDI, which is also administered by the EDD, similarly to the FMLA. For SDI, it's a 52-week time period, whereas paid family leave, like we talked about for baby bonding, is simply 6 weeks. As with New Parent Leave Act, there is also the maintenance of health insurance requirement that does need to take place. Coverage has to be maintained during CFRA following PDL and FMLA, so after the mom is no longer disabled by pregnancy, on baby bonding time, just like with the New Parental Leave Act. With FMLA CFRA, it's that grant of leave, but also along with it comes the right to reinstatement, where the employee does need to return to the virtually identical position. If you do require a medical release for the employee to come back, you do need to let the employee know that at the time they take the leave, so they're aware of it. Resources to get a little bit deeper into this, of course, the Department of Fair Employment and Housing link is there for you. There's quite a bit of information there that can help you navigate. I've talked about a lot, and it's complicated and confusing. I'm hoping that you just have a few nuggets to take away in case you know that you might be in a situation where you need to grant leave. And of course, the California Chamber of Commerce, we do offer a whole host of resources that are also helpful in navigating the leave requirements as well as every other. So with that, thank you.
Thank you, Erica. Just a question at the beginning when you talked about notifying an employee of taking a leave.
Yes.
What kind of recommendations do you have about, should you have like a standard form that you hand an employee?
Yes, so with the New Parent Leave Act, Cal Chamber, we've created a notice. There's no required notice language. So yes, I think with the New Parent Leave Act, for those of you that are under that, I would put, some kind of form that says, we have guaranteed the right to reinstatement. This is the time duration of the leave. So everybody knows they're taking it on this date, they're going to come back this date. One thing to note right now is the New Parent Leave Act, whether it'll provide intermittent leave, that's where the DFVH is going. We just don't have any guidance on it. With FMLA CFRA, there actually are designation notices and forms required under the law that you would want to use, and those are downloadable.
Okay, one other question that came to mind. So obviously like colds and flu don't fall under that, but there are other diseases that might be on the cusp, like hepatitis and things of that nature. Could you expand on that?
So serious medical condition is the trigger for FMLA and CFRA. So if you have somebody with a chronic condition, somebody who might be diagnosed with cancer, somebody who might suffer from a mental illness that requires ongoing treatment, diabetes, where they have to be away from the office for dialysis treatment, those are all going to be the forms of serious health conditions. The thing that we all have to remember as employers is we do not want to play doctor, okay? So that's where that form, the designation forms, come in handy so that the employee can take it to their physician to fill out, to help you figure out, is this a serious health condition or not? Typically if there's something that requires ongoing treatment or leave, time away on an intermittent basis, that's where it's going to come into play.
Okay, one last question then. How do these laws apply to companies with less than 20 employees?
Yep, they don't apply.
At all.
At all. So if you have less than 20 employees, none of these laws apply to you. You might have employees who want to take paid family leave, and remember that's a wage replacement. It's going to be up to you and your policies as to what you want to do.
So if you have 20 employees, but they haven't met the time threshold,
that's right. So again, go back and make sure that you've hit all those elements,
Right.
that you might be an eligible employer under the new Parent Leave Act or under FMLA CFRA, but your employee hasn't met the eligibility thing. The one thing that I just want to leave a note about with the new Parent Leave Act is while it did take effect in January of this year, I want all of you to be aware that if you had an employee who had a baby, let's say in November, they can take that new Parent Leave Act now. Time out because they've got a whole year from the birth of the baby. So that is something that I want everybody to just be aware of. It's that year of time that they have to take the 12 weeks.
Okay.
Okay.
Thank you.
You're
Thank you,
very
Erica.
welcome.
This is very informative.
My pleasure.
Appreciate it. We're going to mute for a few moments while we change speakers, so stand by. Welcome back. We're here today with our second speaker. This is Bill Krisha. He has a long history with Cal OSHA and the Division of Occupational Safety and Health, spanning over 37 years. He has managed Region 2 Enforcement Unit for over 20 years. He has recently focused on agriculture, health and safety, and heat illness prevention and enforcement. He has been a team leader for the division's emergency response team. He is a board-certified industrial hygienist, and we are pleased to have his expertise today to talk about indoor and outdoor heat illness. And this is a really hot topic in our industry, Bill, so everybody is waiting to hear from you, and maybe you can preview the upcoming workshop or the advisory committee on this as well.
We will talk about that a little bit this morning. So I wanted to start off and talk about the Cal OSHA program so that everyone understands that the Cal OSHA program does cover you folks. We'll talk about the heat illness prevention standard, how it applies to solid waste collection. We'll talk about some of the documents that are online because one of the key issues I think is what's indoor and what's outdoor. And we'll get into that detail in just a minute or two. And then some very generic at the end enforcement data. I've shared some other data with Veronica, and she may share it with you folks shortly. Okay, so the Cal OSHA program applies to all non-federal work sites in the state of California. We have a consultation program. The consultation program, those are the good guys. They're really there to help you folks. When I worked for the division, I worked on the enforcement side. And so I say that I whack people for a living. And so that gets a lot of attention, especially from the ag communities. But the enforcement side writes citations and there's penalties. The consultation side responds to employers' requests, either through telephone consultations or on-site consultations that address issues like their safety program, lockout, tagout issues, and anything else that you may, occupational safety and health-wise, that you may want to deal with, workplace violence perhaps, or heat illness prevention. So they talk about that. The enforcement side is what everyone classically thinks of as Cal OSHA. We're the folks with the hammer. We respond to complaints, we respond to accidents. We also do programmed inspections. And so we go out to high hazard sites and look for issues. Again, we issue citations. There are penalties associated with that. And you have rights of appeal on those things. And so if we need to in the future, we can chat about that a little bit more. But we also can shut down imminent hazard work sites. We do that rarely, but we have that authority. So the heat illness prevention standard, section 3395 out of Title 8, currently covers what we call, and I have air quotes, I'm doing air quotes right now, you can't see me, but I put some on the slide, for outdoor work sites. And so we'll really get into what does outdoor mean. But it also requires water. Usually when I do presentations, if I was there, be a little bit more interactive, I'd ask you folks, you need to know when we show up, how much water you have to have. And the answer is 1 quart per hour per employee. So I can't hear that, but I'm assuming that you're all thinking that. So that's cool. All right. So you also have to have shade, rest for employees. Employees are entitled to a minimum 5-minute rest in the shade, and emergency response and training. It also requires a written program on the part of the employer that addresses all these issues. And we can ask for that on an enforcement inspection, and you're expected to have it. So if you don't have it out in the field, we can issue a citation for that. And in fact, data from past years indicates that by far that's the most common citation that we write. This is a horrible PowerPoint slide. But the reason I wanted to give it to you is you now have it as a resource, and it talks about the question and answer document that's on the Cal OSHA or DIR, Department of Industrial Relations webpage, and says, what do we mean by an outdoor place of employment? And we've written these Q&A documents, so probably since, I think, 2011 or so, to kind of define what it is. And without reading the entire thing to you, the short version is, hey, listen, if it's got a roof and it's got walls, but it's hotter in there than it is outdoors because the HVAC system, heating, ventilating, and air conditioning system isn't working, or there isn't one. So it could be a metal shed, a structure, a lean-to, something with a roof and 3 walls or 2 walls, or any combination of that, where folks might say, oh, that's indoors. Nah, that we treat that as outdoors. There has been a lot of confusion about that, okay? And so one of the questions that we have is we have folks who say work inside a structure that does have swamp coolers or is cooler than the external environment, but they're indoors part of the day, they're outdoors part of the day, right? And so I presented a decision from the appeals board here for the Coca-Cola company that basically says, hey, you still have to have a program. If you have employees who work outdoors, even for part of the day, but they do work outdoors, got to have a written program, got to present that. Okay, indoor heat. Because of all this confusion and because of issues from the legislature, the division has created an advisory committee meeting. I understand that some of your staff will be attending.
We'll be there.
I plan on attending. That'll be this Thursday in Oakland. And so we'll talk about indoor heat issues. And under this standard, and I included the link on that, they'll get a chance to see the PowerPoint, right?
Yes.
Okay, so hopefully the links will be hot and you can click on it, and there'll be more than you probably ever wanted to know about, the potential for indoor heat. But quickly, there are two models, 2 proposals right now. One is to take the existing standard, Section 3395, and modify that to more clearly address the hazards of indoor heat in the workplace. The other option is to have a separate standard that addresses the issues of indoor heat in the workplace. I don't want anyone in the audience to think that if they have issues with indoor heat, right? Because parts of the state, you cover the entire state, right? Parts of the state, I get the weather reports still from San Diego. I think it was 91 or in the 90s down there, just recently. And so if you had structures outdoors, warehouses, sheds, other things, it could easily be 100, 110 degrees in those structures. You have people working in there, they're covered by the standard. They're either covered by our interpretation of the outdoor heat standard, because that structure would be hotter than the external environment, the outdoor environment, or we would cover that under our injury and illness prevention program, which hopefully all your audience understands. And so that requires you to identify unique hazards in your workplace and correct them, right? And so we can talk about that, or you can ask me questions about that. But anyhow, we're trying to, I should say retired down at the bottom, but the proposal is to establish a more clear standard to provide more precise instruction and direction at a minimum to employers. It addresses or raises some new issues. If you're somewhat familiar with the outdoor heat standard, without getting too technical, we talk about dry bulb temperatures. The trigger temperature for shade is 80 degrees. The trick question I usually ask, and there's no pop quiz that's going to pop up on your screens right now, but the trick question is what's the temperature is water required? The answer is water is required all the time, right? And we'll talk about water in just a second or two. But for out or indoor heat, the proposal is temperature is in the workplace, indoors, over 80 degrees. There is a potential exemption, a draft exemption, if it's between 80 and 90 degrees for fewer than 4 days a year. Okay? And that the workers aren't exposed to high levels of radiant heat from a furnace or a stove or an oven, commercial oven, or anything like that. And they're not engaged in high metabolic heat load work. So it gets a little complicated. You'll get a chance to see that. But it also raises the issue of humidity in the workplace. And so it brings in the concept of heat index and a bunch of other things that may be novel or new to folks. Okay, so high heat. Under the existing standard, we have a high heat provision. So transportation is one of the 5 industries that are covered under this. So potentially, if you folks are transporting materials, you would be covered by the high heat provisions. And we talk about that, and the high heat provisions kick in at 95 degrees. And so you have to have at least 1 quart of drinking water per hour per person. That water has to be as close as practicable. There's some confusion on the agriculture side because there's a separate standard for field sanitation that talks about restrooms being within a quarter mile or a 5-minute walk. However, for your industries, as close as practicable, means it has to be there.
What about in a truck?
What about in a truck? You have to have water in the truck, right? So they have to carry water in the truck if they're going to be at different sites or sites where water isn't accessible. If they're at a fixed structure where they're sorting materials or something, that's possibly one of the activities your members may be engaged in. If they have plumbed water there and employees have access throughout the day to that, that's acceptable, right? Water has to be fresh, pure, suitably cool, and provided to employees free of charge, which means if you have folks who are traveling, they have to have access to water. And if they run out of water, they have to get water free or they have to be reimbursed for that, right? And the frequent drinking, of water always has to be encouraged. Okay, shade. This gets a little wonky sometimes because, especially with folks in transportation, doesn't mean you have to have an air-conditioned vehicle. The standard doesn't say that, but you can't necessarily use that vehicle, the non-air-conditioned vehicle, as shade. What happens with a vehicle? There's a lot. We've already lost kids this year who have been left in vehicles. There's a whole big public health issue, public safety campaign about leaving kids in cars, right? And so what happens is cars heat up pretty quickly. Vehicles heat up pretty quickly. 85-degree day, there are videos on YouTube you can see by the auto manufacturers where within 10 minutes, it's 120, 130 degrees in the vehicle. It's, that's not acceptable. That's not acceptable shade. Well, yeah, there's a roof over the top, and the windows may be tinted, but the vehicle still gets too hot. And that really puts an additional burden on folks. So the shade has to be as close as practicable. So again, if you have folks out in the field and you have awnings or partially shaded areas, that's fine. Employees don't have to always work in shade. But when they take breaks under the standard, which was revised in 2015, when they're on breaks, they have to be able to take breaks in the shaded area. Okay. We also talk about if shade's not feasible, alternate cooling methods are acceptable for your industries. That's allowed. For agriculture, they have to provide shade. But for you folks, you could use misters, you could blow cool air on folks and everything else. Okay, first aid and emergency response. A lot of this should be a no-brainer to everyone, but the key thing that I've seen in looking at, because I've looked at all the accidents that have occurred that Cal OSHA is aware of since about 2005. And so one of the key things is if someone feels ill, it's a high heat situation, you're in Reading or Bakersfield or El Centro or whatever, wherever you are, and someone feels ill, there's a human tendency, hey, boss, I don't feel good. I want to go home. You need to evaluate that person and see what's going on under the standard. Because we have had situations where employees are experiencing heat illness, which can progress very rapidly. And they die on the way home, or they get home, they're seriously ill, they go to the hospital, and they die at home, or they die in the hospital subsequent to that. There's data that supports that. So the standard, again, that was changed in 2015 says you can't just leave people alone, because we had that problem on the agriculture side, again, because I'm looking at that a little bit more closely, where they would say, hey, if you find you want to take a rest in the shade, you can go sit down there. We'll come back 2 hours later, and you find the person dead. That's not acceptable. Okay, so the standard says you have to. Now, supervisor doesn't have to observe them. They can be supervised or observed by a lead person. But again, training, you have to know what's going on. You have to figure out how you're going to deal with these things. Okay, high heat provisions. We chatted about this a little bit before. They're covered. I think your industry is covered, especially when you're doing transportation. You have to ensure effective communications. And that means either through radio, cell phone, or whatever. Especially if you're out in the boonies or you're traveling, you have to be in constant communication. You have to observe employees for signs or symptoms. Again, you have to remind folks to drink water. And you have to have pre-shift meetings. It's going to be over 95 degrees that day. And this could be a short meeting. Hey, it's really hot today, going to be hot today out there. We have plenty of water. Veronica's our lead person. Do you have any problems? You contact Veronica or whoever. Don't always call Veronica. She's very nice, but she doesn't need to hear from you guys all the time. But I mean, whoever your supervisor is out on the field, right? That employees have access to. And make sure that they know that they have a right to take a cool down rest. We also recommend through some of the reference materials we're talking about, buddy systems or whatever works for you folks. You have to have something to work with your employees and observe them. Lots of references. Tons and tons of references. If you're feeling overwhelmed by everything I'm saying, hey, that's okay. But we don't want you to feel that there's no support for that. I mean, the organization, by inviting me here, has started the dialogue, I think. There's tons of references here. Cal OSHA consultation does not bite. They are there to assist you folks. If you don't, you're reluctant to deal with that, you can go online. And so these references, the 99 Calor website has all kinds of material that you can download and print and share with your employees. A lot of the material is in Spanish. Some of the materials we have a few other languages. We have posters to share. You can go online, call consultation, and get big glossy flip chart kind of things to assist in your training. There's tons of good stuff out there. Okay, let's leave heat for a little bit and talk about, this is the NAICS code, the industry codes for solid waste collection. That's the number that I looked up, and hopefully that covers you folks. And I looked at 2015 to present. There are about 27 inspections of the state, 11 had citations, 12 were in response to accidents. Veronica has the detail on those that's available to anyone on the public web. And I looked at citations, and some of these citations, I'm using the word wonky because I have a son and he's into Thomas the Tank Engine, and it kind of means things are not quite right. But when you look at this, the most frequent citations are abrasive wheels. To me, what this means is the inspector who went out there really had a thing for abrasive wheels and he's looking for abrasive wheels. But air tank permits, a real common citation for folks. So if you have an unfired pressure vessel, which would be an air tank, and have a permit to operate, right? It has to be there, okay? Section 2473.1 is basically electrical boxes. You have to make sure all your connections are appropriate. The monster in the room, the two monsters are 3203, the Injury and Illness Prevention Program. You folks have to have one. It has to be effective. Employees need to know about it, and hopefully they're aware of it. Again, Cal OSHA consultation has tons of information on that. And then finally, section 3314 is lockout, tagout. That's what I call it. It's basically de-energizing a piece of equipment before you work on it, whether it's a garbage truck, whether it's a press, whether it's an electrical panel, all those kinds of things. That's a huge standard, and you need to have not only written programs, your employees need to be trained on that. The big thing, I don't know how we're doing time-wise, but the big thing that I've seen is that somebody comes on board and says, yes, boss, I know how to do that, right? And so we'll say, well, okay, we need somebody who knows how to TIG weld. And somebody will say, yeah, I TIG welded on the space shuttle years ago. It's nah, don't believe them. I mean, make sure that you train them. You have that obligation to train them, make sure they know what they're doing. Okay, and with that, I think, questions?
Well, I just would ask a couple that have come up. So, you know, a lot of our employees, transverse, you know, they're in the cabs of trucks picking up garbage.
Right.
So indoor, outdoor heat, define that.
Well, I think it really depends. If they don't get out of the vehicle and the vehicle is air conditioned, then we would most likely consider that to be an indoor environment, right? Mm-hmm. And so, and it is air conditioned and they don't have to get out of the vehicle, then, you know, they would still be covered under the injury and illness prevention program. You'd have to have something, but you probably wouldn't have to have a written program. I have affectionately called myself over many years the evil enforcer. And the reason for that is because I don't believe that they don't get out of the vehicles. I believe that they do get out of the vehicles. And I do believe that you would have to have a written program that would address the outdoor heat standard, right? And you would have to fulfill the minimum requirements of the outdoor heat standard. So, I mean, that's my feeling. If they work outdoors, if they're doing sorting at a recycling facility or something like that, clearly they're covered. Okay, we had a situation a couple of years ago, one of the things, very unfortunate situation, where they were using developmentally disabled people. And so this is very sensitive, but they may be more prone to heat illness. And so, you know, again, I'm aware, and the attorney just left the room, but, you know, there are discrimination issues and all that kind of stuff. I'm not suggesting you do any of that. I'm just suggesting you be a little bit more cautious with those folks as far as working, especially when you have extreme heat conditions. Mm-hmm. One of the things that I do, and I didn't include in the slide, is check the National Weather Service. I mean, they're on the Facebook, right? And so whatever area you're in, you can get the local office. And so you can, it's a great business use for Facebook, because they'll have forecasts, they'll talk about watches, warnings, and special weather statements. So you as an employer can understand, hey, it's gonna be bloody hot and high humidity, and it's for everyone is at more risk today. So let's be a little extra careful out there.
And one more question. A lot of our facilities have like roll-up doors because of the type of business that we're in. And so can you give a little guidance on how you would manage that indoor, outdoor, in terms of the regulations? It feels to us like we're a little bit in a classification of needing some customization due to the nature of our business. Maybe talk a little about that.
Okay, so I mean, roll-up doors in and of themselves, over 37 plus years, I've seen issues with roll-up doors. So there are safety issues with roll-up doors I'm not really gonna address here. But as far as heat goes, again, what's the structure like? One of the examples that I throw out frequently is the Tehachapi area. You know, they've got they got a boneyard out there for aircraft. Really neat place, right? But it's 114 out there, and they have these metal structures, and it's 120 or 130 degrees inside these structures. Roll-up doors open, roll-up doors close, you know, a little warmer. So the issue of the roll-up doors, I mean, doesn't necessarily make it indoor or outdoor. Again, I'm cautioning you folks that don't get hung up on the distinction right now, because there is an indoor standard coming. We're going to cover it either way. And currently, under the Injury and Illness Prevention Program, hey, if it's a hazard, you have a roll-up door, you're working inside, but it's warmer in there, you know, we'll apply Section 3203, the Injury and Illness Prevention Program. We've done it successfully in the warehousing industry, and we've sustained it through multiple appeals. So, I mean, that's going on right now. And with if we do pass a standard through the advisory committee meeting, it'll probably happen, my guess is in 2019. It still has to, go through advisory committee meeting, the standards board. You guys know all that stuff. But don't wait for that. Please don't wait for that. If there's a hazard to employees, indoor, outdoor, think about those kind of things. Work with Cal OSHA consultation. Work with this group, and let's help minimize the risk of heat illness to our employees.
Thank you. There's a question from one of our participants wanting to know if they're required to have thermometers in the workplace.
So the issue is that, and it's always been this way for a while, if you don't have the standard doesn't say you have to have a thermometer. The indoor heat standard starts talking about, wind velocities and wet bulb globe thermometers and a bunch of other really nifty basic industrial hygiene stuff that I don't have the time to get into right now. But yeah, I mean, we're going to talk about radiant heat under indoor heat. We're going to talk about humidity inside the workplace under indoor heat. You'll experience some of that this Thursday when we go to the meeting. You have to have some way of determining. Now, if you put shade up at the beginning of the shift and employees have access to shade for all their breaks and everything, you don't have to worry. They're working outdoors. You don't have to worry about, the trigger for shade is 80 degrees Fahrenheit. It's also or upon employee request, right? So if you have shade up all the time, that's cool, right? You don't need to do that. If temperatures are going to be 95 degrees according to the weather service, you check it the day before. Hey guys, it's going to be hot out here today, blah, blah, blah. Under high heat, we have to do this stuff. Remind you guys to drink water frequently, take more frequent breaks, do all this other cool stuff. Then that's okay. You don't need a thermometer. But if you want to be ornery, my word, don't work for the state anymore, so I can talk like that. You want to be ornery about it and say, well, show me where it says I have to do it. Well, the standard says, hey, when it gets to be 80, you got to have shade up. Okay, all of our inspectors have thermometers. I'm telling you, the first thing they do, the first thing we trained them to do, besides saying, hey, I'm here from Cal OSHA, is start, taking temperatures and recording that data. So is it a good idea? Heck yeah. I mean, are they expensive? I mean, you can pay, we have wet bulb globe thermometers that cost $1,500. We also have thermometers that we bought at Home Depot that are like $15, $16. The thermometers in your car, I'm not real thrilled with those, but it's a thermometer. But just remember too, work sites change, microclimates change. So if you're in an office, you're a safety director and you have people out in the field, those conditions out in the field may be significantly different. California's just a fabulous state. We have high heat warnings in one part and we have freeze warnings in another part of the state. You folks cover the entire state, I believe. And so, you need to be aware of conditions at the site. I would strongly urge you to get a thermometer. I don't have stock in that. Okay. And I don't know how well the market's doing today. A little volatile, I think.
Well, thank you. This was just fabulous. So we really appreciate this, and we're looking forward to working with you and the advisory committee. And maybe just to kind of close out on that, the advisory committee meets this Thursday on indoor heat, the discussion, and then I think that the whole process has to go back to the legislature with a recommendation, right?
Well,
by January of 19.
Right, they'll come up with a recommendation. It'll go through the standard setting process.
Right.
When you're there on Thursday, we actually have a really nifty handout that talks about the process. You'll have access to that, and you can post it on your website for all your members to see. But it takes a little bit of time. But on the other hand, I want folks to understand, it's been hot this spring already, folks. Again, temperatures down south in the 90s. And so start thinking about heat illness. Start thinking about having a program. If you don't have one, go online, call Cal OSHA consultation. There's tons of resources. There are folks there to help.
Well, thank you. This has been very helpful. We appreciate it very much.
Thank you. Thank you for the opportunity.
And just for all the participants, just a reminder on all the presenters today that if you have follow-up, some burning question that you think of in 10 minutes that you want to ask Bill, please email those to Kelly and we will try to get responses to your questions back to you. Thank you. Stand by, please, for our third speaker. Good morning. Welcome back to the webinar. This is Kathy Lynch, and we have our third speaker here, Chris Shimoda, is the Vice President of Government Affairs for the California Trucking Association, where he has been employed for over 10 years. He has spent much of his career working with various California agencies, including the California Air Resources Board, the California Highway Patrol, where he worked on the development and implementation of major programs and regulations impacting the trucking industry. He participates in several boards, including the California Freight Advisory Committee and the South Coast Air Quality Management Plan Advisory Group. We are honored to have him here today to talk about the California meal break laws, of which we get many questions. So absolutely. I know you're going to answer them all today, Chris.
Well, thank you, Kathy. And speaking of meal breaks, I know we're almost 2-1. We're getting very close to lunch, so I'll try to be as brief as possible. Again, my name is Chris Shimoda. I'm Vice President of Government Affairs with the California Trucking Association, and I will be doing an overview of everyone's favorite subject, meal and rest break law in the state of California as it pertains to the trucking industry. And big thanks to the CRRC for the invitation to participate today. And so first, a very important disclaimer. As you know, you're on this webinar, so you understand what I'm about to say. The laws and regulations governing California meal and rest breaks are extremely complicated. And while I'll be walking through some of what the law says on this matter, I just want to double underline, I am not an attorney. And so I highly advise you, if you have any questions on your meal and rest break policy, please do consult your labor and employment counsel to make sure that your company policies mitigate your litigation risk. Just my take on this is it's almost impossible to eliminate your litigation risk on this topic, but there are things that you can do internally to try to lower the risk that you'll get taken to court by your employees. And if you'd like any references, I'd be happy to provide them. Our association does work with several very, very good labor and employment attorneys. And so if you do need a reference, my contact information is there on the screen. Okay, so just a quick overview of what we'll cover. So first, we'll just talk about what does the law and regulations governing meal and rest breaks require, including some of the gray areas in the law. Next, we'll discuss the legislative landscape on meal and rest and how that may impact things moving forward into the future. There's some things you should know on both the state and federal side. And then last, we'll do questions and answers. Okay, so what does California law require of transportation employers? So generally speaking, the law requires a 30-minute meal period for every 5 hours worked and a paid 10-minute rest period for every 4 hours worked. So diving into meal periods first, off-duty meal periods where the worker is relieved of all duty are considered non-compensable. So you don't have to pay that worker for that 30 minutes that they're having their lunch so long as they are relieved of all duty. There is some fairly significant gray area in the interpretation of what relieved of all duty means. If you have any questions about your practices in the transportation world, a lot of times we have things like responsibilities to keep custody of the vehicle, sleeper berths. I know that's not as common in your neck of the woods, but for many of our employers, they have to stay in a sleeper berth during their breaks. Hazmat issues. So just please do consult an attorney about your policies on, whether or not the employees are relieved of all duty. I can just, highlight one significant case on this in the refuse industry. I take a look at that LA sanitation case from 2014, where the Bureau of Sanitation actually had policies regarding naps during break times, and then also whether or not drivers could congregate together during meal periods. They ended up having to settle that case because it was found to violate the relieved of all duty standard. And so again, this is a very seemingly simple issue, but one that can get you in a lot of trouble if you're not careful. So in the transportation industry, it's obviously not uncommon for drivers to work long periods. So it's important to note that you actually do owe a second meal period once the worker hits 10 hours. Meal periods can be waived by the mutual consent of both parties, both the employer and employee, under certain conditions. If the employee does not work more than 6 hours, the first meal period can be waived. And so if you do have someone doing some part-time work or less than a full day, under 6 hours, that employee can waive that meal period if they would just like to, get done with their day. A second meal period, so the one that is required to be provided after 10 hours, can be waived again by mutual consent of both parties if the first meal break was not waived. An on-duty meal period must be compensated. So if you have a situation where it's not practical to relieve the worker of all duty, and you end up entering into an on-duty meal period agreement, which again, if you have any questions on that process, please do consult your legal counsel. The on-duty meal period must be compensated at the regular rate of pay, which, it's important to note, is different from the employee's hourly rate if the worker earns piece rate or other non-hourly compensation. Okay, and now on to rest periods. So rest periods are a paid 10-minute period owed to the employee for every 4 hours worked. And I have the actual language on this slide, but instead of going into how and when rest periods are owed, I just put together a table that outlines the number of rest periods that are owed per how many hours your employee works. And so just to make it a little bit more simple. So as you can see, if you get up to interstate maximum of 14 hours on duty, you could owe the employee as many as 3 rest periods during their day. And same as meal periods, during the rest period, the employee should be relieved of all duty, and the break, this is what the law does say, should be provided insofar as practical in the middle of that 4-hour period. And so, to take it out of the transportation context for a second, if you were just a straight hourly worker in an office, working an 8-hour shift, what your employer would, ideally do is after 2 hours, provide that 10-minute break during the first 4-hour work period. And then during the second 4-hour work period, provide another 10-minute break after 2 hours. And so in our world where we have non-supervised, non-office drivers out in the field, doing a variety of complex tasks, running into traffic, other sort of practical issues, what the law does say is that where it's not practical, the employee just needs to be provided a break at another point in the work period. So a lot of room for interpretation there, but if that driver does not take that break at 10 minutes, at the middle of the 10-minute break at the middle of the 4-hour period, just make sure that they get that break at some point in the work period. Okay, for those of you who have drivers who are in collective bargaining units, there is a collective bargaining exemption in California Labor Code for meal and rest periods, so long as the collective bargaining agreement provides for the provisions listed there on the screen. As you can see, it's pretty extensive. And this exemption does only apply to Class A, B, or commercial Class C drivers. And so it's very specific to those folks. If you have any drivers running routes that require just a non-commercial Class C, this exemption would not apply to them. And so anything under 26,000 pounds where you're not doing hazmat or anything else that requires a commercial endorsement. Okay, so a few other considerations. In 2012, the California Supreme Court heard a very big case on meal and rest. And the question was whether employers actually had a duty to ensure employees were taking their meal breaks or merely had a duty to provide them. And so this was the Brinker v. Superior Court case in the Supreme Court. Employers were hoping that this clarified a lot more than just these issues on meal and rest breaks. But what came out of that case was that the Supreme Court held that employers have no duty to ensure that meal breaks are taken. But what the employer must do is provide a meal break by relieving employees of all duties, and that employer policies should not in any way encourage the skipping of meal periods. And so where employers are found to have violated meal and rest break law, the employer, let me back up for a second. So essentially, what that case meant to you as an employer is that, so let's say your driver is out, performing their duties, talking to their dispatch, but otherwise not supervised directly. You are not actually required to, pull that driver off the road by the 5th hour and ensure that they're taking their meal breaks. That's sort of what this Supreme Court case said. But what you should be careful for is that what the Supreme Court sort of left there as interpretation is they do not want to see employer policies that weigh heavily on the side of, either coercing or incentivizing the drivers to skip their meal breaks. And so this is really important when you're looking at your meal and rest break policies and sort of doing your employee orientation on these issues. You really need to sort of consider removing as many paths and barriers that may be imposed by you as the employer to the drivers taking those 30-minute breaks. And so, there isn't necessarily a duty to say, hey, at the 5th hour, I don't care what you're doing, even if you're in the middle of doing a route and there's nowhere safe to stop with the vehicle. You're in the middle of a neighborhood or whatever the case may be. Or on the 405 in the middle of a traffic jam, you just need to make sure that the employee is sort of given as much of a free path to taking that lunch break by the 5th hour. And then just a note on penalties, as you all probably know, if you've had any class action litigation on this subject or have been following both, sort of the class action side as well as the PAGA claim side. Meal and rest breaks figure heavily into, pretty much every class action lawsuit and PAGA claim that we've seen on the trucking industry side. And the reason being is that the penalties really stack up. If you have not done a good job with your internal policies and they've been found to violate the law, or you're simply not documenting when employees are taking their meal and rest breaks, the employer can be liable for up to an additional hour for every meal break missed, and then also an hour for the rest breaks missed with a 3-year statute of limitations. So you can imagine at the regular rate of pay, going back 3 years, that's essentially 2 hours per workday. That can really add up fast, for those of you who have, dozens, if not hundreds of employees, subject to meal and rest. So let's address some opportunities to fix this issue. Since, I'm the Vice President of Government Affairs, this is sort of where my mind goes. I can tell you that there has not been major legislation on meal and rest breaks for commercial drivers since 2008. There was an Emerson bill that actually instituted the collective bargaining agreement exemption that year. And we at the association have looked at a few pathways since to take a run at meal and rest. But, my assessment professionally would be there is not a lot of room to address this issue. There just really doesn't seem to be any appetite to revisit the meal and rest fights of, sort of the last decade. And so, looking at the legal front, it doesn't get much, much more optimistic on that end. If any of you are in current litigation or follow this sort of stuff, we've really run into a lot of issues in the Ninth Circuit, raising federal preemption defenses. That's sort of our go-to in the trucking side. The F4A rates, routes, and services preemption arguments have been rejected in several high-profile cases on meal and rest. And so we're sort of at a crossroads as far as our industry is concerned on this issue. And so given these difficulties, both the California Trucking Association as well as our national organization, the American Trucking Associations, are currently pursuing a federal fix. Congressman Jeff Denham from the Central Valley has actually been the champion for the industry on this issue. The federal fix is actually known as the Denham Amendment. And what the Denham Amendment would do is provide a specific preemption of state meal and rest laws for employees whose hours of service are regulated by the FMCSA. And so if you have commercial drivers who are logging their hours, that you're following the 11-hour on driving, 14-hour on duty hours of service with the 30-minute mandated break by the 8th hour, your driver would be covered by the Denham Amendment. And what this would allow is for a more specific federal preemption next time, if a plaintiff's attorney does try to pursue this in court, we're going to have a lot more ammunition going into, that fight. We are also pushing for this change to be retroactive, so the preemption arguments could be raised for your existing liability going back several years if there's existing litigation where the statute of limitation is told, whatever the case may be. We are pushing for this to go retroactive all the way back to 1994, so it would wipe out, any sort of legal liabilities on the table. And we are attempting to get this language inserted as we speak into the federal omnibus package. And so, hopefully if we are successful, that's going to, trickle out through various trade publications, and it'll be a pretty big victory for the industry. And so, again, just want to thank the CRRC for the invitation to speak today. I'd be happy to take any questions that you have. And also, I would just highly encourage you to keep close to your legal counsel who does labor and employment law on these issues. It is a very, very unsettled point of law with a lot of financial liability.
Chris, could you address the timeline on the congressional bill? I know you said it might be part of a package, but
sure.
Could you go over the schedule?
So Congress is considering, as you guys probably remember seeing, the very, very short weekend government shutdown. What that had to do with was what's called a continuing resolution, which is essentially a short-term budget bill. Typically does not include what are called policy riders or things that Congress wants to get done on a short-term basis. We are looking to either get attached to the major long-term spending bill or the next continuing resolution. And so we're expecting to see something on this. I think the last CR was 3 weeks, so it should be coming up here in the next couple of weeks. And so we're hopeful to get a resolution on this, hopefully this winter.
Okay. Another question, just kind of put a highlighter on this. So if you have a labor contract versus a non-labor operation, can you kind of talk about the distinction there?
Sure. So for those of you who do have collective bargaining agreements, just take a look at the requirements, and I'll go back to the slide. So you can get out from some of the requirements of California Labor Code on meal and rest, so long as these specific sets of issues are addressed in your collective bargaining agreements. And to be honest, I have not really heard from our members, to the extent our members do have drivers that are covered by this exemption, how it has worked. The only thing I can really say is that there is one union employer that did want the exemption to cover just straight Class C drivers, so long as they were in vehicles over 10,000 pounds. And so I'm assuming that means that they're pretty happy with the way that the CBA exemption has worked out. But again, if you do not have a union workforce, if your drivers are not covered by a collective bargaining agreement, everything else that I covered in the presentation applies.
Okay, thank you, Chris. I just want to say thank you to all the participants today and to our 3 speakers. And I want to especially acknowledge the California Trucking Association and the California State Chamber of Commerce, of which CRRC is a member, and we very much appreciate their participation today. Thank you.